One, myself Dr. Chittaranjan Nayak, working as an associate professor in Vidya Pratishthan Kamallan Bajaj of Engineering and Technology, Baramati. Today we are going to study about arbitration. Introduction to arbitrations. Arbitration is nothing but it is a dispute resolution board. In arbitration we are finalize the dispute among the two parties, or it is useful in civil contract. First, introduction to arbitration. Disputes are part of human living. The dispute in any time in human life there is a dispute. So dispute in are part of human life. In ancient time, disputes referred to village, panchayat for speedy settlement. In previously in villages, panchayat used to settle the dispute. During British rule, arbitration was encouraged. Arbitration Act 1899 was the first act, replaced by Arbitration Act 1940 as full code. The Arbitration and the Recognition Act 1996, based on the UN Model Act, was passed in 1996. Act provide for domestic arbitrations, international, commercial, and enforcement of foreign arbitral award. So these are the some arbitrations which is used in India. Then what are the modes of settlement of disputes? First one is capitulation. Weaker party gives into written goodwill along term business relationship with strong party. Then second mode of settlement of dispute is negotiation. Both parties seek difference and try to each friendly settlement. Then arbitration. Arbitration is impartial third party appoint to judgment. In if there is a disturbance in two parties, then the third parties, then there is a umpire judge, the third party which has to settle that matter. This is comes into the arbitration. Then litigation. Dispute takes to court, resulting in abnormal delay and heavy expenditure. Then last one is dispute resolution board. Board constituted on award of contract to resolve disputes as and when they arise. Then what is meant by arbitrations? The arbitration is the settlement of a dispute by the decision not of a regular and ordinary court of law, but one or more persons chosen by the parties themselves, who called as arbiters. Thus, arbitration is a domestic court where the arbiters act as a judge. The arbiter can either proceed on the basis of his knowledge or take evidence and then given his decision on such incidents. In both sides agree to be bound by arbiter's decision, award become a binding arbitrations. Exact procedure to be followed, if not included in the contract under dispute, governed usually by country's arbitration laws or by arbitration rule prescribed by International Chamber of Commerce (ICC). If there is no procedure followed in contract document, then there is a law which is provided by the government. Then advantages and disadvantages of arbitrations. Then advantages: it is private, there is no public record of any proceedings, although not necessarily confidential. It is the advantages, done in privately. Then speed, although this depends very much on the manner in which the arbiter conduct the arbitrations. It is speed, there is a speed, fastly it is working. Then parties can agree on the arbiter with relevant expertise in the matter. The arbiter would can be enforced as a judgment of the court. This is the advantages of arbitrations. If there is some advantages, there will be some disadvantages. And disadvantages will be the parties must bear the cost of both arbiter and the venue. Sometimes arbitration simply mimics court process, and so you do not get an advantage of informality and speed. Limited power of compulsion or sanction if any party fails to comply with directions of the arbiter, which can significantly slow down the process. So these are the advantages and disadvantages of the arbitration. Then arbitration, what are the objective of arbitration? Make a provision for arbitral procedure which is fair, efficient, capable of meeting need of specific arbitrations. To minimize supervisory role of courts, arbitral tribunal to give his reasons for the award, to ensure arbitral tribunal remains within jurisdiction, permit arbitral tribunal to use mediation, conciliation or other procedure to settle the disputes, to make decision of tribunal enforceable as a degree of court. Then definition, these are the some definitions which are used in the arbitration process, or you must know what are the definitions, or it is also useful in the examination. This is arbiter, a person appointed to settle the dispute. This is arbiter. Both parties when appointed one third party, this is called as arbiter. Then arbitration agreement, a written agreement between client and contractor to settle the future disputes. Then order of reference, order containing names of the arbiter, specific dispute, nature, time limit for award. Then presiding arbiter, an umpire when each party arbiter or both party arbiter choose one presiding arbiter. Then award, written decision of the arbiter on completion of the proceeding. So these are the some useful definitions which are used in that arbitration process. Then arbitration versus litigation. Advantages of arbitration over litigation. In arbitrations, more speed is there. The work, whatever the disputes, it is settled in more speed, less expensive, more privacy, informal proceedings, expertise of the arbiter in this field, flexibility in choice of meeting place and locations, finality of decisions, then continued good relation between parties, owner and client. These are very useful and very good advantages of arbitrations. In litigation, this process are not be followed because it may be not maybe speed, because today we are having suppose there is a dispute, it takes much more time. Okay. Then need of arbitrations. The misinterpretation of project plan and contract clauses are bound to come up in the course of new construction, implementations, and for various other reasons mentioned earlier, disputes are like to be come in between two parties. In that case, if there is a misinterpretation between two parties, then there is a dispute, then it is required in arbitrations. These types of disputes are only solved by through the law of courts or arbitrations. Our complex and our best law system makes the judgment through law courts extremely time consuming, and it takes up to 20 years. If you go for litigation, then this is very time consuming, or it may be take to 20 up to 20 years. That's why we are following the arbitrations, because it is speed in nature, in object. Departmental officers should themselves make every effort to appoint an arbiter for quicker disposal of such cases. Then it should be understood that process of important and national development projects are jeopardized for what to timely settlement of such problems. Because of that arbitrations, then main works will be whatever the nation's good work, then it is speedily done. Then qualification of the arbiter. An arbiter should have following qualifications. The arbiter must be judicial and impartial in the arbiter, should not be related personally to any other parties, and he shall be free from ill feeling against any of the parties. He can be person who has expert knowledge in the particular branch or of profession and the matter in dispute. He must have online high integrity and unshaken faith in justice. The person who not below the rank of superintendent engineer generally selected as an arbiter. So these are the qualification of the arbiter. Then power of arbiter: the administrator to any party to the arbitration aggressively as may in the opinion of the arbiter. The administrator pleads to the parties and witness appearing to state of special particular case for the opinion of the court, to correct the mistakes or any problem in award arising for expectation or accidental slip, to make award of alternative or qualified, or an arbiter is empowered to make award which is binding to the parties, binding on the parties. The arbiter has an authority to award to grant interest if there is a debate payable with interest. The power of the arbiter can be experienced on the following heads: power to make the award, then power to take assistance, then the power to rule on its judgment. So these are the main three powers which is with an arbiter. Then qualities of an arbiter: arbiter should be important and fair to both the dispute parties during the arbitration process. He has to play a role of third and distant judge during process of arbitration. He must give equal opportunity to both disputing parties while collecting evidences. The arbiter should be conscious and always abide by the norms of nature, justice and equality while carrying out the arbitration proceedings. He should not be a person suspicious character. So these are the important for qualities of an arbiter. If these are not there, then the dispute may be going to make more serious than this. Then role of arbiter in civil engineering work: an arbiter reviews testimony and evidence presented by the dispute parties at hearing and resolves the dispute by issuing a decision that may include an award of money. You can think of an arbiter as a private judge hired by the disputing parties to resolve their dispute. If the arbitration is binding, the parties cannot seek a reversal of the decision in court except under any limited circumstances. However, the successful party can seek help from a court enforcing the arbiter's decision. An arbiter serves as the decision maker and referee in an arbitration proceeding, much like a judge during court litigation. The arbiter is bound by the rules outlined in the parties' arbitration agreement. If he is a member of a special arbitration organization, such as the American Arbitration Association, he will be bound by the rules of the organization as well as a set of ethical rules. In civil engineering projects, arbiter means very important role, because in civil engineering aspects there is a there are huge work in civil engineering. It should be maybe something huge work as well as huge change in the plan, sections and construction activities. Then it may be there is something dispute about labor, then it is from contractor, owner, then it is very important in civil engineering work. Then appointment of arbiter. Section 11 of the Arbitration and Conciliation Act 1996 provide for the appointment of the arbiter. The arbiter can be appointed under the following means: appointment by the parties or appointment by the court. The arbiter may be appointed by two types, maybe it is maybe party or made by court. If parties are appointed, then party may be agree to appoint a solo, one or arbiter or more than one arbiter. An arbiter named by the party and so appointed can be proceed with the arbitration proceeding. If the parties do not name their own arbiter, they may be mutually agree the arbiter may be appointed by the third designated person. 11(4) or 11(12) of the said act confer upon court the power to the appointment arbiter. Court in the context means the principal civil court of original jurisdiction in a district and include the high court. The general rule is that power of appointed arbiter is vested in the parties. An arbiter clause is interested to that effect in the arbitration arrangement. In case one party fails to appoint an arbiter on request of reference, the other party may file an application to civil court for appointed arbiter. In both cases, you can appoint an arbiter if you can appointed by the both parties or appointed by the court. Then type of arbitrations, generally there are two type of arbitrations. First one is voluntary arbitrations and compulsory arbitrations. In voluntary arbitrations is a binding adversarial dispute resolution process in which the disputing parties choose one or more arbiter to hear their dispute and render a final decision or award after the expedite the hearing. Voluntary arbitration impels that the two contending parties, unable to compromise their difference by themselves or with the help of mediator or conciliate, agree to submit the conflict dispute to an impartial authority whose decision they are ready to accept. Under voluntary arbitrations, the parties to the dispute can and do they refer voluntarily and dispute to arbitration before it is referred for jurisdiction. These types of reference is known as voluntary reference. For the parties themselves volunteer to come to a settlement through an arbitration machinery. The essential element in voluntary arbitrations are the voluntary submission of dispute to an arbiter. In voluntary disputation, there is a binding, the adversarial dispute resolution process in which the arbiter will be appointed and the two party appointed by two party, then it will be resolved. Or in compulsory arbitration is a non-binding adversarial dispute resolution process in which one or more arbiters hear argument, weigh evidence and issue of non-binding judgment on the merit after an expedite hearing. The arbiter decision address only the dispute legal issue and appeals legal standards. Either party may be reject the ruling and request to trial de novo in a court. Compulsory arbitration is one where the parties are required to accept arbitration without any willingness on their party. It will be decided by the compulsory arbitration. Then procedure for arbitrations. Specific clause to be introduced in contract setting dispute by arbitration. Then agreed party to approach the designated authority to appoint arbiter with list of all selected dispute and amount of involved for the each dispute. Arbiter is then appointed with list and referred with the papers submitted. Few contract provided for direct resolution of dispute by parties. Failure to do can lead an appointment and an arbiter. Arbitration conducted under the provision of Arbitration and Conciliation Act 1996. Parties are to be treated on equality and given full opportunity to present their cases. Parties are free to agree on the procedure of arbitral tribunal. Parties free to agree on the place and language of arbitrations. Arbitration proceedings start from date of receipt of request from arbitration. State facts supporting the claim, issue involved and remedy sought. Respondent to give defense against these claims. Tribunal to decide on oral documentary evidence. Experts appointed by tribunal in case of specific technical issue. Assistant of court may be sought for taking evidence. Decision of the tribunal to be by majority being in odd numbers. Award to be writing and assigned by all members. It is to be reasoned award unless otherwise agreed to the or to by parties. Award amount if not paid to carry interest at 18% per annum for date of award to the date of payment. Award to be final and binding, enforced other dates of the civil court. So these are the procedures of arbitrations. Then characteristics of a good award. In characteristics of a good award, it is sticking to the scope of the defense defined issues. Only sticking to the scope of the defined issue, it not be further other way. stick to the time limit. It should be follow the time limit, whatever the time is provided. Unambiguous, unconditional, complete and clear decision. Clear decision should be provided, no conditions, etc. Judgment and decision that are judgment and decision that of the arbiter only and no one else. Only arbiter will be give the decision. Complete application of mind of arbiter. Complete applications of minds of arbiter. Okay, so today we just see what are the arbitrations, or what are the causes, what are the types, what are the role of arbitration, what are the definitions, are various types of definition, etc. all these things. It is very useful in the civil contract for settle the dispute and everything. Thank you for listening. Thank you all.